Hello, everyone. My name is Michele Ubertone. I'm an assistant professor at the University of Maastricht. And today I'm going to expand on what Corrado Roversi said in the first part of the lecture and talk about the experiment that was run by me, by Corrado, by Luisa Lugli, Caterina Villani, and Stefania D'Ascenzo at the Legal Theory and Cognitive Science Lab. It is an experiment about Hart's notion of the internal point of view, and you should already know what this is because Corrado talked about it in the first part of the lecture. And he also told you about embodied cognition. He told about this new approach to the study of concepts that has been developed by recent cognitive science. In this part of the lecture, I'll try to bring together these two topics, the internal point of view on the one hand and embodied cognition on the other hand, because the topic of the experiment that we ran was precisely to draw on embodied cognition to learn more about the psychological underpinnings of what Hart calls the internal point of view. Let's start by reminding you the distinction between the embodied view of concepts and the traditional view, which is also the naive view that most of us presuppose when we talk about concepts. The naive view about concepts, the traditional view, is that concepts are merely criteria of application. So criteria of application of words, they're basically definitions. So my concept of a banana is a set of necessary and sufficient conditions that I can use to recognize a banana and to use the word banana appropriately. The embodied view is very different from this. According to embodied view, what we have in mind when we think about a banana is not a set of necessary and sufficient conditions. It's a very complex pattern of activation of neurons that is the result of a set of interrelated experiences that I had about bananas. So my concept of a banana is a pattern of activation of neurons formed in interacting with the reference of the concept, so with bananas, but also with people talking about bananas, with people referring to bananas, to images of bananas. And this activation of neurons corresponds to various very different types of things. So abilities, like the ability to peel a banana, memories of perceptions, the smell of a banana, the color of a banana, experiences I had where bananas play some role, and so on and so forth. So the traditional view about concepts is that concepts are very tidy, are just a very synthetic set of formal necessary and sufficient conditions for the identification of the reference. The reference is what a word stands for. But the embodied view says no. The concept is something much more complex. So our criteria of application of a word are just the result of a very messy set of experiences or memories of experience that we can retrieve when we think back. So basically, our experiences shape this pattern of neurons, and we are then able to reactivate that pattern of neurons even when we are not dealing with the reference, even when we are not. When there are not bananas around, to stick to this example. In the classical view, traditional view, concepts are amodal, which means that they're not associated with any specific feeling. having the concept of a banana doesn't feel like anything, according to the traditional view. Whereas, according to the embodied view, having a concept does feel like something. And concepts are conceived as multimodal, which means that they are associated with different types of sensory motor experiences. So the idea that we had is that this conception of concepts, this approach to concepts, can actually help us understand a little bit better what Hart calls the internal point of view. Let me just remind you what the distinction is between the internal and the external point of view according to Hart. According to Hart, all legal norms can be used in two different ways, and also concepts that are constituted by rules, like the concept of a contract, for example, the concept of the president of a republic. All these types of concepts can be used in different ways, in language and in thought. You can use them to describe states of affairs or to justify or criticize legal conclusions. Normal citizens usually take the external point of view. They merely use legal concepts to describe things, whereas experts in law, jurists, legal scholars, judges, legal officials of all kinds take the internal point of view because they use concepts to justify states of affairs or criticize states of affairs. Let me make an example of this. Suppose you are in your office and there are sheets of paper on your desk and someone asks you, what is that? You take the sheet of paper, you say, well, this is a contract. Contrast this situation with another situation where you are holding that sheet of paper in your hands and you are showing it angrily to your boss, and you are uttering exactly the same words. This is a contract. And in that situation, the same speech act has the function of making a point that that contract should be respected. Maybe you are complaining that your boss has not fulfilled with some obligations that you think she has based on that contract. So in the first situation, where you just point out that that piece of paper is a contract, by the way, it's just a document proving a contract, if you want to be precise. But in any case, in the first situation, you are taking the external point of view. In the second situation, you are taking the internal point of view. You are invoking the concept of a contract not to describe something in the world, but to advance a legal claim. So we thought that if it is true, as embodied cognition says, that concepts are basically the trace of our past experiences with dealing with a certain reference or dealing with a set of related situations, then a consequence of this would be that jurists and non-jurists may result to have different types of concepts because they take different points of view on law. So there should be some sign in the concepts we have of the use of this concept that we made. So people are used to using concepts to criticize and justify conclusions. People who take the internal point of view will probably have slightly different concepts from people who don't take the internal point of view, people who are just normal citizens who just use legal words to describe things rather than to make legal arguments. So what did we do to test this hypothesis? we presented two groups, a group of jurists and a group of non-jurists, with different lists of words. Some words were actually related to legal concepts. We call them institutional concepts, and you see a list of them in the right side of this slide. But we also asked them to rate other types of concepts, just to make sure that what we found is actually peculiar to legal concept. It's not just a general behavior that people have with all types of words. And we asked them to rate these various words according to different dimensions. So what do we mean by dimensions? But basically, we asked them to say how those concepts or those words were associated with certain feelings or certain sensations, certain types of emotions. So, for instance, we asked them, how much are you able to imagine the reference of these concepts? How abstract do you consider this concept? How familiar are you with the concept? How tactile is the concept? How is it associated with a tactile sensation? And so on and so forth. Basically, what we were trying to do was to understand what the pattern of neurons we were referring to before was like in the group of jurists and in the group of non-jurists. Our idea was that legal concepts like contract will be rated in a significantly different way by jurists, lawyers on the one hand, and non-lawyers on the other hand. And if this were the case, Hart's idea of the internal point of view would receive an empirical or some degree of empirical confirmation. And also, this could also help us understand what exactly are the psychological underpinnings of the internal point of view. What does it mean psychologically to use a concept to criticize or justify a state of affair? The experiment gave positive results. It actually turned out that experts and non-experts in law conceptualize legal notions in a significantly different ways. So they rated those concepts differently in various significant dimensions. Lawyers conceived institutional concepts, rated institutional concepts as more contextually situated, more familiar, but this is not surprising. They thought they were acquired at an earlier stage, but they also associated with a positive valence. They had a positive idea, more of a positive idea associated with words like contract, for instance. And this is significant because this shows how these concepts are conceived as practically relevant in deciding what is correct or is not correct. So this is actually suggestive of the idea of the internal point of view. They also are more able to they associated it with a tactile sensation, which is also interesting. They have a more a less abstract and more concrete perception of what those words mean. Within the category of institutional concepts, we also drew a distinction between pure institutional concepts and meta-institutional concepts. Pure institutional concepts are concepts which are constituted and can only be understood with reference with legal norms that exist in a legal system. The precise meaning of the word contract varies in each legal system because it is basically defined by the rules, the positive positive legal rules of each and every legal system. Whereas words like justice or validity are more like the basic grammar of law, and they must be presupposed for the understanding of rules. They are not constituted by rules, but must be presupposed to understand rules. So we wanted to see if there was also a difference in the way both groups conceptualized pure institutional concepts on the one hand, and meta-institutional concepts on the other hand. Pure institutional concepts like contract, concrete, precise, and technical concepts like contract, as opposed to broader evaluative concepts like validity or justice on the other hand. And here too we found some interesting results. Experts in law rated both meta-institutional concepts and pure institutional concepts as being more associated with positive mental states, emotional states. But they rated meta-institutional concepts in particular as more contextually situated, more concrete, and as less associated with language. They think them as being something more practical and less just linguistic. This is also very interesting. It seems to suggest that jurists are more able than non-jurists to see the practical consequences of very abstract and apparently unpractical legal values. So, under the traditional rule, the traditional view, concepts are basically criteria of applications that we derive from norms. We have a mental representation of what the contract is just because we know what the law is. And these criteria determine our application of concepts in specific situations. We saw that concepts in general, we're not talking about legal concepts in this slide, but concepts in general are not criteria of applications, are activation of complex patterns of neurons that are basically the result of our past experiences in dealing with a certain reference. How does that work with legal notions, which typically don't have a precise reference? And this is what we came up with. So there is a practice, a legal practice in which jurists are involved. And this practice is, of course, the result of the application of legal concepts made by other jurists. But this practice is communicated to each jurist through linguistic rules or practical activities. These activities create a set of experiences that jurists happen to associate with an augmented perception of concreteness, with specific emotional reactions, and with the evocation of specific contexts of applications. This, in turn, produces the criteria of application that jurists use to decide cases or to apply legal notions. What is particularly interesting is also the fact that jurists seems to be more able, as I said before, than normal lay people to associate abstract legal values with practical contexts of application. This gives us a more complex and a detailed view of what the internal point of view is. And we hope to make more studies to see how cognitive science can help in the understanding of this fundamental notion of legal theory. Thank you very much.